Welcome to On the Move.
And Mr. Randall?
I guess at this point the city would rest, Your Honor.
Okay. Members of the jury, we're going to take a brief recess. And Mr. Freeman?
Yes, Your Honor. I would actually like to move the court to dismiss the charge for insufficiency of evidence and for unconstitutional application of RCW 941270. And I would, refer the court back from a legal analysis perspective to the motion, the NAPSTAT motion, and the legal analysis that was presented there. When in order to find a violation of the statute, there has to be several things. They got in the city of Vancouver, and we're not going to address that, but the statute requires, and they also displayed a weapon. That part of the statute is satisfied, but the statute requires the city to prove that the display or the carrying of the weapon was in a manner and under circumstances and at a time or place that warranted alarm for the safety of others. Now, that warranted alarm requires it to be objective. It does not matter that Dustin O'Brien applied the policy of Big Al's. It does not matter that Sherilyn Powson was upset. That it doesn't. The question is whether or not the city established that he carried it in a manner and under circumstances and at a time and place that objectively warranted alarm for the safety of others. Now, what's clear is that, and look at the case law, is that it is not illegal to open carry a semi-automatic rifle. It isn't. But if this case is permitted to go forward, then it effectively is, because Mr. Worley did nothing other than walk around with that rifle slung over his shoulder. He didn't touch it. He didn't point it at anybody. He didn't do anything. So when you're looking at the in a manner portion of this statute, if this court allows this case to go forward, there can be no manner in which you could carry it. Because I don't know how else he could have carried it or displayed it. It would make it effectively a violation of your constitutional rights, or effectively illegal just to possess it. And we know it's not. You can open carry a firearm in public, period. I think under the facts of this case and under the same analysis that I presented in the NAPSTAT motion, there is insufficient evidence. And the application of this statute to these facts violates his Second Amendment rights. I'd ask the court to dismiss.
Okay. Thank you. Motion will be denied. Using the test I have to use at this point, I would find that there is sufficient, on kind of a twofold argument, sufficient evidence this time to go forward to the jury. But again, a jury questions whether or not they feel that it did warrant alarm. There's sufficient evidence that it could. As to the second one, that's something we could even address later as well on the constitutional argument. But at this point, motion denied.
Thank you, Your Honor.
Am I being detained right now, officer?
Let me see your ID.
No, thank you.
What's that?
No, thank you.
No, thank you?
No, thank you.
Okay, why are you saying no, thank you?
I know it's my Fourth Amendment right. I don't have to show you my identification. Okay, so you're not going to answer me. Okay. What's your badge number?
1382.
And your name?
Devlin.
Devlin. Yours?
1375.
Name?
Trey.
You do know that you're required by law to actually give me your name when I
just
ask.
did.
Really comfortable too. That's one thing I really like about this bag, is the comfort level of it. But anyway, so let me move on here and we'll start showing the back here, show the features. First thing first here, we got the front of it.